Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 o'clock. So for those of you who are here early, thank you for waiting patiently. And while we're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you very much for joining us for today's online talk. It's called Eviction of Squatters, a Landowner's Right to Vacant Possession. My name is Jasmine, and I'm a paralegal with Mawing Kwai & Associates, and I'll be your moderator for today's session. So before we start, let me just introduce the firm and talk about what we do. We are a mid-sized law firm that was founded in 1985 by Dato' Mawing Kwai, and our team today comprises of about 28 lawyers, and we have a support team of 17. Dato' Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. And the firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with 4 departments, main departments: the corporate team, the dispute resolution team, the employment team, as well as for individuals and families. And our practice groups indicate that some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. So today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel as well. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. So our speakers for today will be Ms. Vivien Phan, as well as Mr. Jeong. Allow me to introduce your speakers to you. Ms. Vivien is a senior associate in our dispute resolution department, as well as the individuals and families department. She got her degree, a Bachelor of Laws from Cardiff University in Wales, UK, and she was called to the English bar in July 2016. She was then admitted to the High Court of Malaya in 2017, and today her practice areas include criminal litigation, land acquisitions, general litigation, debt recovery, probate and administration of estates, contractual disputes, as well as tenancy disputes. And our next speaker, Mr. Jeong, he is an associate in the dispute resolution department, and he had obtained his Bachelor of Laws from Northumbria University, United Kingdom, and was subsequently called to the Bar of England and Wales. His current areas of practice include land disputes, corporate litigation, negligence, tortious disputes, contractual disputes, arbitration and mediation, enforcement of foreign judgments, defamation, as well as general litigation. At the end of this talk, we will be having a Q&A session. So please post your questions in the chat box at the bottom of the screen. And today's talking points, of course, eviction of squatters and the landowner's rights of vacant possession. So I will hand it off to our first speaker.
Thank you, Jasmine, for the introduction. As Jasmine has mentioned, today's topic is on the eviction of squatters, especially the rights of a landowner. Squatters or individuals who occupy land without legal right to do so is a very common issue in Malaysia. And dealing with those squatters can be both complex and, of course, a very challenging process. So we hope that with this online talk today, we get to shed some light on the legal framework and the procedures on dealing with squatters. So show you on the first point is, who are squatters? The Oxford Dictionary defines squatters as person who unlawfully occupies an uninhabited building or unused land. So what does this mean from a legal perspective? It means someone who occupies a piece of land or property without the legal right or even the right to do so, especially if there's no legal title in this manner. The next slide I'm showing right here is one of the landmark cases, which is Datuk Bandar Kuala Lumpur and another against Tan Powa and others, 2008, 11 MLJ 198. In this case, the term squatter is legally defined, which is right at the bottom, which says he is one who, without any color of right, enters an unoccupied house or land, intending to stay there for as long as he can. He may seek to justify or excuse his conduct. He may say that he was homeless and that this house or land was standing empty, doing nothing. But this plea is of no avail in law. This would actually mean squatters are not recognized by law. Now, this case reaffirms position from the previous slide, the case of Datuk Bandar. This case basically reaffirms the legal position that squatters have no rights either in law or in equity. And as you can see from the slide as well, there's another case, developments in John Berhad against HS. Again, it recognizes the fact that squatters have no right either in law or in equity. So after identifying what squatters are, or rather who are the squatters, what are the proceedings, what are the court process in evicting squatters? Now, before we deal into this area, one of the practical point of view, how do you identify a squatter from a layman's perspective? One of the most common ways is actually by observing whether there's any existence of any makeshift buildings, tents, structures. Some structures may even be made of wood or metal. So what are the court processes in evicting squatters after identifying them? One of it is initiating a legal proceeding for trespass under the law of tort and claim for damages. Now, this will be by way of writ action, which will follow on with a statement of claim. Especially landowners who are seeking to regain possession of the land may also face the issue of lack of knowledge of who the squatters are. Now, in a writ action, it is important, or rather it's a requirement, in other sense, to identify who the defendant is as the plaintiff. In a situation where landowners can't identify who the squatters are, their name, and that the way to do that is under Order 89. On Order 89 Rules of Court 2012, which states the following: where a person claims possession of a land which he alleges is occupied solely by a person, not being a tenant or tenants holding over, who enter into or remain in occupation without his license or consent, or that any of predecessors entitled of his, the proceedings can be brought by originating summons in accordance with provision of this order. In short, Order 89 of the Rules of Court 2012 gives landowner the right to seek possession, or rather regain possession of his land, if the landowner does not know the identities of the defendant. Now, this is in addition to filing a writ action under the trespass of under law. The procedure of evicting a squatter, firstly, we have to initiate it by way of originating summons, and this originating summons must be supported by an affidavit in support. Affidavit in support is basically a deponent who deposed the facts and knowledge personally known by this person, And in this affidavit in support, and as shown in the slide, these 3 points must be stated. Firstly, what are the landowner's interests in the land? And number 2, the chronology of events that led to the unlawful occupation of the land. And lastly, and the landowner does not know the name of each of the squatters despite deploying all reasonable steps. Now, this is a very important point. Reasonable steps must be done to ascertain the name of the squatters. And inside the rules of court, it is also important to note that the contents of the affidavit in support must be strictly adhered to. Should any of this information not be present in the affidavit, or rather the rules are not followed, there's a strong possibility that the originating summons might be rendered defective and voided. So in a situation where if the identity of squatters are identified, the originating summons can and be served in accordance with Order 10, Rule 5 of the Rules of Court, which is just a personal service. Or number 2, by leaving a copy of the cost papers or sending it to the squatter at the premises. Or in some situation, the court might give certain directions on how the cost papers might be filed, and in such manner, follow such manner as directed by the court. Now, complication may arise, and normally it will arise, when the identity of squatters are not certain. So in this situation, the cost papers for Order 89, which is originating summons and affidavit in support, should be affixed or rather pasted on the main door or the main entrance of the part of the premises. For example, if it's a shed, at the front part of the shed, or if it's a building at the front part of the building. And number 2, if practicable, if there's a letterbox present in that said building, put inside the letterbox, and it must be addressed to the occupiers of the building, illegal occupiers rather. After the papers and which is originating summons affidavit has been served, there will be a hearing, and this hearing should usually begin 5 days after the service of cost papers, unless of course if there are exceptional cases or urgent cases, then the leave of court would have been sought for to grant for urgent hearing. Now, as mentioned before, Order 89 is a summary proceeding, so which means if there is a dispute of facts, it is very highly likely that a judge might order a full trial of the matter instead of just serving the cost papers for Order 89. This is decided in the case of one and another. After the order has been granted for Order 89, a writ of possession will be the next paper to be filed and issued. Now, there's a timeline on doing so, which is 3 months. So 3 months after the order for Order 89 has been granted, order as in the court order, the writ of possession would have to be issued within 3 months from the date of the order that's been given. Should any landowner only issue this possession after 3 months, then the leave of court would have to be sought for to grant this writ of possession. And how would this order be executed? Once the possession has been issued, the court would generally issue a notice for vacant possession, and then a court bailiff would be appointed correspondingly. In the notice of vacant possession is basically a court document which states what the squatters or rather the defendant in that Order 89 should do. Normally in this notice of vacant possession, the court will give a timeline as to when the squatters are supposed to vacate the landowner's land. Usually it's a 14 days period, though the court may vary this timeline. And the court bailiff is there to execute this as well. As a matter of practice, after the expiry of 14 days of this notice of vacant possession, the court bailiff, with the assistance of the police officer, would generally be present at the land itself to ensure compliance with the notice of vacant possession. It's also worth noting that there may be some fixtures or structures on the land, and in that situation, landowners might need to consider the prospect or rather the idea of engaging a contractor to be present at that time, even the police, to demolish those unlawful fixtures, buildings on affected land. It is pertinent to note that it is a standard, as a matter of practice, best practice, to do so when the police and the court bailiff is there, because of course it is also to ensure a more peaceful and amicable way of demolishing such fixtures and structures. Now, this leads to my next point. What are the common pitfalls and challenges of evicting squatters? One of the most common ones are uncooperative squatters. These are squatters who are rude, perhaps, or unruly, or may cause disturbance during the enforcement of the notice of vacant possession. Though it should be mentioned here that it is not uncommon for the squatters to still be illegally occupying the land, despite the squatters already being made known of the existence of a valid order under Order 89, or to an extent, maybe even the notice of vacant possession has already been issued to them. So it is very important at this stage that landowners do not take matters to their own hand during the enforcement of writ of possession. Again, like I said before, as a matter of best practice, it is best to seek the assistance of the police when necessary, especially when there's unlawful buildings erected on the land and external contractors are sought for to demolish such buildings. This, of course, is to protect everyone, to make sure everyone is safe, and to ensure proper order can be maintained. Another issue that landowners might face in this situation is logistical issues. Because there's a quite short timeline, it's only 14 days for the defendant to comply. In a situation where there are more complex buildings, for example, a multi-story shed, a multi-story building being erected on a land, the landowner might need to make an arrangement as soon as possible for contractors to demolish such buildings in a safe and a manner which would not affect the neighborhood as well. Again, during this stage, during the demolishment, the squatters might intervene and cause interruption to the demolishing process. So once again, it is a good practice to contact police at this stage if any of the squatters decide to intervene. Landowners should not take matters into their own hand to ensure everyone's safety. My next slide, I will show some of the common cases, or rather important decided cases that gives the right of repossession of the land to the landowners. The first one I'm showing is the case of Yak Chang versus Ko Sao Chun and another. This case basically states that the test for Order 89 is based on the right of possession. The question that has to be asked is whether, given the peculiar circumstances of the case, the plaintiff has the right to possession of the land. In essence, this means whether a plaintiff or rather a landowner could have cause of action or rather has a right to issue Order 89 is dependent on whether the landowner has the right over the land. This is usually in the form of land title. Land title will be very good proof that the landowner has rights and benefits and interests over the land. The second case that I'm showing is the case of Shah. In this case, it is stated that there must be no tribal issues of fact or law. As I mentioned at the beginning of my presentation, Order 89 is a summary proceedings, which means there should not be any issues of facts, or rather no tribal issues. The second that there's any tribal issues, the matter will refer back to trial, and the landowners cannot seek 89 and issue a writ of possession thereafter. In essence, this means that the landowner must establish that there's no dispute on the possession of the land. That's what this case of Shaheen, and again, one of the more landmark cases, the federal court case of Siddiq bin Haji Muhammad. It reaffirms the principle that squatters do not have the right in both law and equity. And in a court of equity, courts would generally not assist a squatter in resisting an order of possession which is illegally acquired. There are other methods of dealing with squatters. Order 89 and issuing a writ may not be the only option. Another option is actually by way of negotiation. This is just a simple oral negotiation between the landowner and the squatters for safety purposes, of perhaps even for maintaining a public order. Such negotiation should be done in public place. One of the benefits of doing a negotiation is that it's very straightforward. It's relatively easy because it's it could be settled between parties if everything goes well. And of course, it's cost effective because it would normally not cost any money to set up a negotiation, or rather minimum amount of money. However, there are disadvantages to this negotiation process. Firstly, of course, the squatters could be rude and unruly, and this could pose a problem to the landowner, both safety issues and of course, the issue of maintaining public order, which leads to my second point of these disadvantages. There might be a possibility of physical danger from squatters. Now, some unruly squatters might present a physical danger to the landowner. So again, at this stage, landowners should not take matters in their own hands and if necessary, seek the assistance of the police. Another way, should there be a legal proceedings, a mediation would be a very good alternative. Mediation is basically a neutral and impartial, independent third party, in this case, a mediator, would facilitate the negotiation process through a structured negotiation process between the parties. The aim of this is to systematically isolate the issues and rather the issues in dispute and develop options or remedies possible between parties in order to reach a mutually acceptable outcome. One of the benefits of this is rather straightforward. The process is conducted by a mediator who will act as a middle person who would facilitate all negotiation process between all parties. And the thing about mediation is it is a voluntarily and a confidential process. So confidentiality is definitely upheld in this manner. And either parties can withdraw or not participate at any point. There are some disadvantages to this method. One of it is there's no guarantee of resolution because the mediator is not a judge. So the mediator is not there to judge who is right or who is wrong. The mediator is rather there to help parties to form a more practical and effective resolution. So at the end of the whole mediation process, there might not be a guarantee resolution. Hence, in that situation, it could be a bit time consuming having had done such lengthy mediation process. And lastly, one of the other disadvantages is that once a resolution has been formed, there might be an issue of lack of enforceability of the resolution. Again, this is not a court order, it's a negotiation process done by a mediator. With that said, my colleague Vivien will continue on with the next presentation, which she will talk about the differences of evicting tenants and squatters. I'll now hand over the torch rather to Vivien.
Thank you, Jeong, for sharing with us your insights. Good afternoon, everyone. I'll be sharing with you the differences between evicting a tenant, holding over, meaning tenants who overstay despite termination of the tenancy agreement or the expiry of the tenancy agreement, and the process of evicting squatters, which my colleague has just explained to you. So tenants holding over cannot be subjected to Order 89 proceedings, which is the summary proceeding to get an order to evict them, because this Order 89 application is only for illegal squatters or people who are illegally staying on the property. If, let's say, tenants who overstay or who are still residing on your property despite the expiry of the tenancy agreement, then you will have to go for a normal suit, civil suit for vacant possession to claim for delivery of vacant possession and also outstanding rental, if any. After you get that court order from the civil suit that you file, if they still refuse to deliver vacant possession despite the court order, then you will have to go for the execution stage, which is by filing a writ of possession to formally take over the premises. Because under the law, you're not allowed to enter the premises even after the expiry of the tenancy agreement without a court order. You may be liable or you may be sued for trespass by the tenants. Unfortunately, that is the law in Malaysia. As stated clearly by this case, Dekat Urus, is that the court refused to allow the summary proceedings because there was a tribal issue regarding whether the alleged squatter's entry onto the land was legal due to acquiescence. In this case, as Jeong explained earlier, the summary proceedings to evict squatters can only be done if it is very clear that they are illegal occupants on the land. If they raise any trouble issues, say they have consent from the state or that they had consent from the landowners via acquiescence, meaning the landowners had knowledge that they were staying there and did nothing, then it can be a trouble issue which the court may then not grant the Order 89 reliefs. I would also like to just share with you something on squatter huts. So it is usually a notice issued by the local authority, say for example DBKL, where there are squatter huts around, and they can issue a notice to these illegal occupants and say that, look, this building is illegal and I will have to demolish it. And that building falls under the definition of squatter huts. It means any house, any buildings, any structures which is erected otherwise than in accordance with a plan approved by a local authority or in respect of a license issued by a local authority. Interestingly, in this case, squatter huts does not necessarily have to mean that it is built by squatters. It can be built by legal landowners, but properties which have not obtained the necessary approval from the local authorities, then they have the right, the BKL or any other local authorities have the right to demolish it, but they have to give you a notice under the essential clearance of squatters regulations. So once they issue the notice, and if you don't demolish it within the certain time, they have the right to enter and demolish it as they wish. Then moving on is to share with you on criminal trespass and squatters. So what can you do apart from filing Order 89 and filing a civil suit to claim for your damages and etc. for fraud against the squatters? You can also file a police report. Whether the police actually do something about it, that's a separate issue, but you have the right to lodge a police report. And most of the time, it falls under the definition, the provision of Section 441 of the Penal Code, which is entering into or remaining on any property without the owner's consent. That itself is an offense under the Penal Code. And it carries imprisonment for a term which may extend to 6 months, a fine, or both. It may also fall under Section 425 of the Penal Code, which is mischief. Anyone who entered the land or property which then destroy or diminishes its value commits mischief. So if they enter a land, they build a property on it that diminishes the value of the land, that itself is an offense of mischief. So usually if the squatters feel like, oh, okay, I'm entitled, I've been staying on this land for so many years, I had a consent, the landowners knew and they didn't do anything about it, then they can raise a defense against a charge of criminal trespass or against the Order 89 application. Apart from the National Land Code, there's also Land Acquisition Act, Street Drainage Act. So there are various laws that deal with trespass, which you can file a civil suit against under these laws for unauthorized occupation of land and also claim for loss and damages accordingly. So just go back on the offenses of criminal trespass again. Most of the time, when landowners go and make a report on illegal squatters and etc., you can also go to the local authorities and also lodge a complaint on the squatter huts that's been built on your property. Just basically just exhausting whatever options that you may have. And in terms of lodging police report, I just want to highlight that most of the time when reports are lodged by laypersons, it really depends how much details you put into the police report and then whether it leads to an action being done. Because based on our experience is that a police report that is properly drafted by lawyers are usually being taken action on because it will have all the elements of the offense in it. So that's just something I would like to share with all of you here. So if you have any issues, just come to us and we can help you to draft the police report so that they can take an action instead of you having the trouble of filing a civil suit, Order 89. At least you're exhausting all your options. Okay, so that's the end of our sharing today. I'll pass the floor to our moderator, Jasmine, to take questions from the floor.
Thank you, Vivien. Okay, so thank you very much, Jeong and Vivien, for the very insightful talk. Now we will move on to the Q&A portion. So viewers, if any of you have any questions, please put them in the chat box now. So we have one question from Su Hao Chu. And it is, may I ask, what are your suggested advice if the squatters have built houses and temples on the premises? Vivien or Jeong, which one of you would like to take this?
Perhaps I can take that. One of the ways to do that is to actually, once Order 89 has been granted, obviously the next course of action is to engage the private contractor, because once Order 89 has been granted, you would have filed your notice your writ of possession, then the court would have granted a notice for vacant possession. At that time, in that notice itself, the court would generally state the timeline that the squatters have to adhere to remove all structures on the land. And in that period of time, these 14 days or however long the court grants, the landowner should seek for the assistance of a private contractor. And at the end of this period, the private contractors and perhaps the landowner themselves should be present at the area to demolish such houses and temple. Because at this time, the police would normally be there.
Our next question is from Catherine Lee, and she asks, what are the elements of the police report that you have referred to?
I'll take that, Jasmine. Thank you. What I meant is elements of the criminal offense that needs to be included in the police report in order to trigger the police to make an investigation on your complaint. Because the offenses are quite spelled out clearly in the penal code. So what we do is that we know what needs to be proved in order for that offense to be committed. So we will draft the police report by including what needs to be included so that it sounds like they have committed an offense instead of just telling the story, this is what happened. Our police report is usually drafted in that way. I hope that answers your question.
Moving on to the next question from Siu Hui Tei. Can I demolish a small shrine that is built on my land without having any order from the court? JJ, would you like to take this?
Yeah, perhaps I will do this. Back to the first question that was asked, whether if the squatters have built houses or temple or premises. Legally speaking, it would be advisable, or rather it's best practice, in other words, to get an order from the court. This is, of course, to protect the interests of the landowner and to not cause any further issues in the future. So the question is, it's best to get a court order.
And the next one from Kevin Xiao. Practically speaking, when it comes to squatters, is it worth pursuing a legal suit against the squatters for damages in addition to getting possession back? How often are any damages actually recovered?
Okay, so I think there's the two parts to this, Kevin. One is whether it's worth it to file a civil suit for damages against them or just get your possession and the land back. It really depends on what's been built on the land and how much it is to demolish the buildings on the land. And then number two is, most of the time, the likelihood of getting the damages from the squatters is very low. But again, it depends who these squatters are, whether squatters can be an established company or an existing association which has money. It also can be illegal foreigners. So it really depends on that. But if the squatters for sure cannot pay you back the damages as you claim, then I would say it's not worth it to pursue that, but just get back the property would suffice.
And occupation of over a year, does it mean ownership for illegal squatters?
I take that. No, the short answer is no, obviously. As I said before, the case of Siddiq bin Haji Muhammad, the federal court case, the court does not recognize the rights of squatters, both in law and in equity. So even if the squatter has been there for over a year, it does not mean it's ownership for illegal squatters. And of course, this is supported in the National Land Code. I believe it's section 341, which gives the landowner the right to repossess or rather gain back possession of the land, despite the tenure of the squatter on the land.
Okay. And when you make an Order 89 application, can it include other reliefs apart from the eviction order, such as damages, declaration, and so on?
Maybe I can take that because it relates to the previous question. Yes, because Order 89 is an originating summons. You can put in declaratory reliefs inside them. Generally, it is, of course, best practice to put it in there. So the court can, at the same time, grant reliefs on whatever the landowners is seeking for, to save costs as well, instead of filing a new suit and whatnot in the future.
Yeah, but to add to that is that, because I think the question you were asking whether to include the damages for the loss and damages in terms of quantum. Yes, Jeong is right in the sense that you might as well put everything in. But if you want to get the possession, the order for possession as quickly as possible, then the advice is no. 89, just ask for possession and then file a separate civil suit later so that you get your possession quick. But if time is not of the essence to you, then sure, go ahead.
Do you have room for one more question?
Go ahead.
if the squatters have been there for more than 20 years, can it be covered under adverse possession and recognized in the Malaysian courts?
Malaysian law is quite clear. No, since the CDEX case is that no matter how long the squatter has occupied that land or that property, no, squatters are squatters. Unfortunately, no sympathy will be given by the courts.
That's all we have for today.
Sorry, I think there's one more from Christopher.
Or one more, is it?
Yeah, I think he's asked, is it okay for landowners to offer financial incentives or similar action in getting the squatters out of the land? Some developers do this. Yes, Christopher, yes. A lot of developers do this, mainly because they don't want to go through the whole court process, the delay and etc. because their project usually have timelines. Yeah, in order to speed up the process, sit with the squatters and try to come with an agreement on how much they want in order to leave the land or get an alternative land for them. Yeah, by all means, you can do that if finance is not an issue in question.
Also, I think Catherine has a follow-up question to the previous question. To clarify, do you mean that the report is worded in such a way that the facts clearly state that the client had every right or reason to evict the squatters, therefore it is immediately clear to the police that your client had the right to evict?
Yeah, usually yes, especially because the person who usually lodged the report is the landowner who has legal and beneficiary interest in the land. It's usually quite clear-cut in that sense.
And also a follow-up to the 20 years adverse possession question. It is not that squatters do not have right in law or equity to occupy someone else's land, but based on your experience, will the court view the matter differently if the squatters have been around for more than a decade and probably with legit electricity from DNB and so on?
Probably take that from Vivien. That's what Vivien stated just now based on the case of CIDIC. The answer is no. The court does not recognize the rights of squatters. And it's a federal court case, so unless it's been reversed, it stands.
That's all the questions that we'll have today. And thank you very much to the both of you for your insights. So before I conclude, I just want to thank everybody for coming to our talk today. And also please kindly join us again for our upcoming talks. Our next one will be on the 3rd of May, and it's on medical negligence claims, what patients and their families need to know. And our speakers will be Mr. Jeremy Balang and Ms. Fong Carmen. And you can also scan the QR code on the screen here to sign up for our online talks. And secondly, kindly fill in our feedback form and please tell us what you thought about our talk. The link to the form will also be posted in the chat. And thirdly, please do follow our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, Facebook. We're on everything. So kindly follow us there. Fourthly, if you'd like to speak with any of our lawyers, we do also offer a complimentary 30-minute consultation over the telephone or over video conference. So please fill in the form on our website. The link is posted in the chat box as well, and scan the QR code on the screen. To our guests, thank you very much for joining us. We hope that you found today's session informative and useful. Thank you, everybody, and we'll see you at our next talk.